As you can see, that's what we are taking on next. A court has told the chairman of the All Progressives Congress to step aside, So I want to discuss that, let's see how that is going to go. The party has said that it's ready to accept the decision and respect the decision of the party, and which granted the court, beg your pardon, Abuja High Court, which granted the interlocutory injunction.
That's from the APC Acting National Secretary, Mr. Victor Gadam, who explains that, the party is law-abiding, and since this is an order from the court, they will abide by that particular order.
However, on the contrary, Mr. Oshiomhole's Chief Press Secretary, Simon Ebegbulem, says his legal team, that's Mr. Oshiomhole's legal team, are currently reviewing the matter and have filed an appeal.
We're still waiting to see that appeal. I've seen a couple of pictures on social media, but Channels Television is waiting to receive that. But there's a whole lot to discuss, definitely.
Yeah, which is why we have a senior advocate of Nigeria, Paul Ananaba, join us this morning. Thank you so much for joining us.
Thank you.
Okay, so here is where we are. Maybe I should ask you this pointedly. As it stands today, who is the chairman of the All Progressives Congress?
Well, some of these questions are not like arithmetic in secondary school, primary school, where you just give the answer 1 + 1 2. But this is a very serious matter.
I asked that, beg your pardon. I asked that because on the one hand, the court has decided. On the other hand, the first respondent has filed an appeal. So that's why I'm asking.
Yeah, that's why I want to get you through it. Yesterday, the court more or less pronounced that by an injunction, injunctive relief, that interlocutory injunction, that the chairman, Oshiomhole Governor Oshiomhole should be suspended for pending his chairmanship, pending the hearing of the substantive suit. I want you to understand that this is an interlocutory order, not an interim order. So it will last until the hearing of that case comes to an end. And if the court reverses it, if the court doesn't reverse it, it becomes a perpetual injunction. Now, a lot has been said about that he has appealed and there's a stay. I want to explain how it works. It doesn't just work. Over time, our jurisprudence have been affected by election cases in which a governor is removed and he says he has appealed. He says he's going to appeal, and then so the public kind of is getting the message that, oh, okay, when an order is made, the man says he wants to appeal, then that order is suspended just because he said he wants to appeal. Electoral laws are different. You have 21 days to appeal in that instance. I'm saying that because this is also politically related.
Right.
Now, in this instance, immediately that pronouncement was made, he ceased to be the chairman. In that case, his chairmanship became suspended until that injunctive order is reversed.
So that's regardless of the appeal.
So, except you are saying that he went to court with a notice of appeal and a motion for stay, and as the order was being made, the appeal was filed and stay. It doesn't work like that. So I want Nigerians to understand how it works. So when that order was made, that order became operational immediately. The judge made that order. And what it means is that if you're a law-abiding citizen, you comply immediately. In fact, from the court, assuming the order was send him to jail, he will march from there. He's not going to say, I'm going to appeal. That's not the way the law operates. So that order suspending him became operational. Now, if he decides to appeal, and I pass a notice of appeal, and say, one, filing those processes does not automatically grant a stay. A stay is a discretion of court. You are saying, I have complied with your order, because that's the first thing to do. But I want to, I have appealed. I want you to suspend this order. Now, that is the way it works. Now, a case like in the governor of Lagos State and Ojukwu, the Lagos State government, did not comply with the order and went to the Supreme Court for a stay. So Supreme Court said, you cannot taunt the courts further by refusing to comply with the order and say because you have appealed and filed a stay. A stay and notice of appeal does not amount to allowing the appeal. And granting of a stay is discretionary on the court. It's not mandatory. So what am I trying to say? Comrade Oshiomhole should have first complied with the judgment. Immediately it was pronounced. He has the right, constitutional right, to appeal. If he appeals, he can file motion for stay, and then the legal process takes a turn. Now, you should also be mindful of the fact that there is an APC Constitution,
Right.
based on which all these things came up. The man had been removed or suspended as a member in his ward. So as at even before the pronouncement of the order, there is a standing decision of the party, internal party democracy, really, that he's been suspended. Now, if he's been suspended, there has been no pronouncement that the suspension at the ward level had been altered. Now, if you are not a member a regular member of a party, how will you be chairman of the party?
So he should have resigned.
No, I am not taking the political wing. I'm talking about legally speaking. You are not a Nigerian, or your citizenship is suspended by some way. You have not challenged it and reversed it, and you are president of Nigeria. It's not going to work. These are the issues. So I'm answering your question so that you can see how it goes. So I went to APC Constitution to say that the Constitution says if there is no chairman, their deputy chairman for that zone or that area becomes automatic acting chairman. Now the issue is, if you now file notice of appeal and a stay, because that's automatic, and a stay, what is the status quo? And in law we say status quo ante bellum, status quo before the war. So which status quo is it now that will lead to pronouncement of some person? I had Mr. is his head who said he stayed the chairman or not. Did he do make legal consultations?
But the interesting thing is this started from the suspension at the ward level.
Yes.
Right? And I'm just wondering, so the party has a constitution.
Exactly.
And the constitution prescribes that once this person is suspended at the ward level, the person is suspended. So it will beg the question, how enforceable first is that constitution of the party? Because it would seem right after that, he was still acting as a national chairman.
Now, there were other prayers in the interlocutory order, which will go to trial, hearing, and reach it, and a conclusion will be made. Because some of the prayers are like, whatever you did within this period in which you were suspended at the ward and all that, it should be void. The court should pronounce that. That's a different, the court will get to that point and decide one way or the other. Section 6 of the Constitution is very clear. Because the only other option for those who took decision perhaps, or who are unhappy that he's still the chairman, even when he's no longer a valid member at the ward level is for them to take to force. The law abhors use of force. The law only recognizes due process, and that due process is Section 6 that gives the courts the authority to decide dispute between parties, and they have gone to court. So we should begin to respect the provisions of the Constitution, provisions of the laws, provisions of constitutions, because he became chairman by virtue of that Constitution. And if that Constitution had provided for that, then he could bring up other applications, but that's not what to talk about here. He can approach the courts to make other pronouncements, consequential pronouncements. But what is not correct is for a court to decide, for example, that Mr. A is governor of this state. He should be sworn in. And somebody says he can never be sworn in. Nobody can be sworn in. And the court says, oh, this person, you are suspended. And somebody says, no, he's not suspended. This country must go beyond that. We should become a country where rule of law is respected. The fact that there's an injunction does not mean that the man has been removed in the sense of pronouncement that you are no longer the chairman, but he's been suspended. And the Constitution has a provision for acting chairman.
Okay.
Why wouldn't we, what is it actually in that seat that
right.
we should throw? No, just before I round up, I've said that many times in this studio. Politicians should allow internal democracy to reign. Politicians should sort their problems out internally and leave us in the courts.
We can't allow you to finish now. We'll be back to take on some of these comments and actually see the junction between judiciary and politics. Stay with us.
What it means is that from this very moment, the first defendant, Mr. Adams Oshiomhole, ceases to be the chairman of APC. That's what it means. At least it's an interlocutory injunction. What it means is that until the substantive suit is decided, he can no longer act as a chairman of APC from this very moment, as the court has ruled. We came for the order because we believe in the rule of law. That's simply the reason why we're here, to make sure that the Constitution is respected. Our contention is very simple, that Mr. Oshiomhole was suspended by his ward. And if you are a suspended member, you cannot reap the benefits of full membership. So all we're saying is that his rights as a member of APC is in abatement at the very minimum at this point in time. That's what we're saying. So we just wanted the court to give voice to what members of his local ward have said.
As a law-abiding party, we will respect all lawful court order and progress from that point. And very soon, the National Working Committee will meet, and you will hear further from the party. But just to say that the All Progressive Congress will respect all lawful order of courts. We will also do that.
This is not a time to rejoice. For us, it is a very sad commentary. Not only because we helped to put that man in office, but because we also have a responsibility to ensure that whatever he does rubs off on the rest of us. But what is even more, the likelihood that a man could abuse his office was so manifest that we feared that the very tenets and the foundations of democracy were being threatened. I believe with what has happened, the court has provided our party a proper atmosphere and a conducive environment for the reconciliation that we seek, so that we can achieve the peace that we need to provide and deliver on the promises we made to our people and to appropriately prepare for the elections that is imminent this year.
On the one hand is the pronouncement of the Abuja High Court. On the other hand is Mr. Oshiomole's press secretary, Simon Ebebulem, who says that the legal team of the APC National Chairman, or former, or suspended, are currently reviewing the matter and have filed an appeal. He mentioned this in a statement sent to our correspondent that, and I quote, "We have filed a stay for a stay of execution and appealed the ruling. With those processes currently before the appeal court, Comrade Adams Oshiomhole remains the national chairman of the party." That's what he says. But Channels Television is yet to receive a copy of the court document showing that indeed an application has been filed for a stay of execution. Of course, you know that policemen have taken over the security at the National Secretariat of the party in Abuja to forestall any breakdown of law and order. Paul Anandaba is still with us as Senior Advocate of Nigeria. This is something that is giving a number of people concerns, given that it's the national chairman of the ruling party. And this is not the first time we are having this kind of situation where the national party, the national chairman of a ruling party, was embroiled in some kind of controversy such as this. Is there any similarity?
Yes, many of the people who are in APC today were former PDP people. Some of the people in PDP now were former APC people. So we have not played politics of ideology. So it's you cross carpet to go anywhere you want, just to. But that is even not the question for today. You could see what that PDP had issues with their own national chairman at some point, and the court had to settle it. Now the point I'm making is, it is because of lack of internal democracy in the parties. Party supremacy is not respected. Really, when you join the party by each party constitution at your ward level, so if you are suspended at your ward level, you are no longer a member of the party, or if you are removed. So at that point, that decision of your party will be respected. Now, where we are now is that it is now a bit beyond a party, because this is a ruling party, and it will impact on the country politically. In some climes, it will even affect even the economy and even investments in the country because of its
what way? In what way will it affect the nation?
Yeah, because the country is already at a high level of concern. I know if there's political crisis in the ruling party, the elections are going to have, even in his own state. It gives worry. If you have investment in Edo State, for example, are you not going to be worried at this point? That's the point I'm making.
Also, the courts have been quite busy this year alone. The courts have decided, election matters. Some say pre-election, some say post-election. And yet again, this is, politics, and it's a build-up to another election. Is this a concern for you?
It's a major concern for me, and every serious-minded Nigerian or legal practitioners. Let me explain to you what happens. Cases in court, at least in the Supreme Court today, that are less than 10 years, except if they are criminal matter cases, sub-exceptional cases, do not have dates for hearing. Because the court is inundated with cases that ought not to have gone there. These are internal party matters that should be resolved. And the Supreme Court has even said timeless. I mean, you see, political parties, charitable organizations should sort their problems out internally within their own mechanism. Now, all this battle, if it's not really addressed properly now, will travel all the way to Supreme Court and increase the list and several others. So it's a matter of concern, and it so much brings judges, lawyers in close contact with politicians. And that is why a lot of concerns, a lot of applications for reviews, a lot of unsavory comments are made about the legal profession.
So you think they
So
shouldn't be
I
close?
don't think it is the best for the country. Deserving cases should go to court, really. What not matters to whether a person should be suspended at the ward level or not. If you are suspended at the ward level, you know what to do. If you are not willing to remain in that party, you know what to do. There are constitutional provisions. But we shouldn't be allowing all this to always get to the courts. It taxes the court system, the revenue of the country, and all that. We can spare Nigeria many of these.
So when you say that, you know, it brings politicians in close contact with lawyers and judges too much, what happens when that happens?
When it happens,
Are they contagious or what?
extremely contagious, because the average politician is likely not to believe in the rule of law. His belief is much more on the rule of result.
What's the difference?
Well, the rule of result is, give me judgment. I want to win. The rule of law is not about I want to win. It's about I want the right thing done. Yeah, I don't know whether you've had if you have had a client who is a core politician,
I've not.
then you understand that you are telling the client, you're giving the best of legal advice. Said, no, lawyer, this is not what we want. We want to win the case, want to win the seat. And you may be surprised that the next minute he has gone to another lawyer who will be willing to do what he wants to do. And many of them begin to shop for judges, for courts and all that. That is not healthy. That is not right. That is why we should minimize the political cases going to courts.
It brings me to an issue, you know, one of the things that I've had in mind since we decided to discuss this matter.
Yes.
The judiciary and politics. They seem to, as Kaudi said the other time, the courts have been busier for political and electoral election matters than for other matters.
Yeah.
How much of that is a concern? How much of a concern is that for the judiciary? And who is taking that on?
Now, it is not the making of the judiciary, it is the making of the legislator, who gave electoral cases timing and says that an election petition will go for 180 days, it goes to appeal 60 days, another 60 days. And you see judges working, some judges becoming sick, some dying. We're considering the difficult circumstances they have to work. So that is why it's not that the judiciary has chosen to ignore other cases, but these are time-bound cases. And they just don't want to have people protest in their houses, go to their families and all that. They will just want to be sure that each case that comes up, they are attended to. Now, if we can reduce the push of the cases, the judges will have more time to even do greater work on the regular cases and even some of the political cases who are the ones that can actually get to the court. And I give you an example. You see now that in many of these political cases, the matter will be heard and stood down for some hours for judgment to be given.
That's right.
That is not the ideal thing. There should be some time. But the Constitution allows up to 3 months for judgment to be given. So it's a thorough look. You know, a court like the Supreme Court should not be rushed.
So do you think that affects sometimes the judgment?
It does. It does. Particularly when we don't have even electronic court system.
Okay, I believe that my colleague, Malkwe, has a question for you. Malkwe?
How do you see matters proceeding from here? If indeed there has been an appeal and no one has been able to ascertain whether or not that appeal has been filed, what do we say the status quo is right now?
That's what I was saying. The Supreme Court stated that in Governor of Lagos State and Ojukwu. The status quo is a status quo antebellum, the status quo before the war. As we speak, I have not seen the notice of appeal and stay. It's not only enough to file notice of appeal and stay, as I've said. have you served those processes? And so what I know is that the order of court became operational from the time it was made and remains until it is set aside or overturned. The issue of stay is discretionary. It is not automatic. Appeal is of right. Stay is discretion. So it doesn't mean that the stay must be granted. But for a party that wants a discretion of court, that party should have also first obeyed the order it wants or judgment it wants to be stayed. So going forward, since the APC Constitution is peculiar in this instance that it has provided for the position of the deputy chairman stepping out as acting chairman, that started this very second that order was made by the court. Now, if you've now asked for stay of the stay, you will now have to go to court to have the court hear the motion for stay and decide whether to stay the order. If the order is stayed, then the chairman, the comrade comes back as chairman. But as it is now, if it was a situation where there was no replacement, immediate replacement, and if appeals and asks for stay, then that judgment will stay if no action has been taken by the party. But the party has already taken action way ahead of time. So that is my position.
Can you tell us, for a number of Nigerians, when they hear things like an interlocutory injunction, what does that mean?
Okay, an injunction is a command. Let me reduce it to the way as much as I can. A command by the court. It can be negative, it can be positive. It can be positive by saying, go and do this. It can be negative by saying, don't do this. Now, if there is extreme urgency, for example, 1,000 trucks of tomatoes had come from Zamfara to be supplied in Lagos, and they had come to Lagos at the Kara Bridge, just next to you here. They were stopped by security for whatever it is. The owners rushed to court, and the court finds that there was no reason to have stopped them. They will rush to court for an interim order, urgent order. Now, the court could say, go and offload the tomatoes first, so that they can be safe. That could be an interim order. Now, interlocutory order is, in that case, the court doesn't, in the interim order, the court doesn't need to hear another party. It's just only you. Now, when that happens, you have to undertake that if what the court has said was you misled the court, you are going to pay damages. You have to make undertaking to ask for damages. But if it is an interlocutory order, what it means is that the court may look at it and say, this is not like tomato that will get spoiled. This is cement. Cement will not just get bad immediately. Let me hear the other party. There will be hearing both parties. Like in the case, in the Oshiomhole case, it's an interlocutory order. The court hears the two parties. Short of saying finally, the court says, having heard two of you, I think you shouldn't continue to be chairman until we conclude hearing this matter. It means that court had heard both Oshiomhole and those who are asking that it should be suspended. It's a more serious order than an interim order that will last for a very short time. So that's what it means by interlocutory order. Beyond the interlocutory order, if the court finishes hearing the matter, because that order in interlocutory will continue until the entire case is heard. If the court finishes hearing the entire case, the court will now make a perpetual order that will never be changed.
Is there a time to that?
The interim order is normally not more than 14 days. In fact, in the federal court, it will expire automatically, except it is renewed. But in interlocutory order, once an interlocutory order is made, it will be there until that case is finished.
Even if it's 2023?
Even if it takes 10 years.
It's interesting you give us this timeline. So what is now new to this is that appeal that is said to have been filed, that,
Yes.
that has been added to this timeline.
Yes.
So what does it do?
The
basically?
appeal is to say, I don't agree with this order you have made. That's an interlocutory appeal.
Right.
That's what Nigerians should also know. The appeal being talked about is an interlocutory appeal.
It's not on the substantive matter?
No, the substantive matter has not been had. It's an interlocutory appeal.
So it has to be
And you are
heard
asking
both
also
sides too.
for stay of an interlocutory order.
Now,
You know?
there's something that you have said a number of times that you have come here, and that is how politicians react when counsel gives them counsel.
Yes.
What is the lesson here for the political class?
The lesson here is that politicians should eschew desperation and listen to professional advice and also seek appropriate professional advice. Because if you have 100 lawyers, you are likely to have up to 50 different opinions. So get
So how do you know who's
the best
professional
of.
then?
No, I mean, for professionals, you should get a second opinion. I advise to every professional advice, seek a second opinion.
Now
And then internal democracy should become a serious matter in this country.
who enforces that?
Well, it is each party constitution says who. But I think we may go beyond that for now to have in the amended
Constitution.
the electoral act now that is being amended.
All right.
There should actually be some provision, more strict provision on issues of internal democracy.
But what does this also say about the average Nigerian's, attitude towards, constitutions, laws? It seems we don't really take some of these things serious.
Yes, because of enforcement and compliance. The difference between Nigeria and any other country I know of that you say is stable and running as, like the UK, US, is compliance and enforcement. We have better laws than many other countries. It's just that when it gets to compliance, the question will be, what is his name? Where is he from? What is his religion? What is his party?
Okay, so then that begs the question of individuals versus strong institutions.
Yes.
How do
Yeah.
we navigate that?
Yes. As I understand political jurisprudence, I don't support institutionalism, absolute institutionalism. I agree with political philosophers like Harry Eckstein, because it is institutionalism also that led to the First and Second World War in Germany. So after the Second World War, it became not fashionable to have strict institutionalism or even strict personality.
So we find a
So
balance.
there has to be a balance. And that's why you see in America, the president is strong, but the institution is strong.
Okay.
So I like a Nigerian society where we have a strong president and we have strong institution.
That's a soundbite there.
I want to thank you very much, Paul Anaraba, Senior Advocate of Nigeria. Thank you so much for your thoughts this morning.
Thank you.
Well, we're back to take some of your comments. Just before we go, please stay with us.